The Honorable Supreme Court.
Good morning, everybody. Thank you very much. Please be seated. And go ahead, call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled In Re Brewster River Mountain Bike Club, Inc. CU application, case number 24 AP 022. Representing the appellants, David Demarest and Jeff Moulton, is Jeremy Grant. Seated at council table with Attorney Grant is David Demarest. Representing the appellee, Brewster River Mountain Bike Club, is Nicholas Lowe. Seated at council table with Attorney Lowe is William Billing.
Okay, thank you very much. Good morning again. Council, come on up if you would, please. We've got a new podium. There's a button. I haven't seen the other side of it yet, so I know there's a button over there somewhere that you can push and raise or lower it. You can probably tune in to WABC in New York if you want.
Yeah. There we go. There is indeed a button.
There is a button, yeah. It's not, there's no trap door, I think.
Although, I mean, it's not the upper trap door.
Yeah. Listen, the first time, never mind. I won't. So, if you would, for the record, introduce yourself and identify your client, then proceed.
Thank you, Your Honors. Good morning. My name is Jeremy Grant, and I am an attorney representing the appellants in this matter, David Demarest and Jeff Moulton.
Thank you.
Counsel, before you get into your argument, can I ask you a question about if you prevail here, what is the mandate that you're looking for from this court? Is it a remand to the environmental court for consideration of the application of the zoning?
Your Honor, that's a good question. What I would say is, I think in the interest of judicial economy, this court has the relevant information in front of it to make a determination on the outcome. And whether that is a remand with a mandate to hold a no hearing or to remand it with an order to remove the bridge would be what we're looking for.
Okay, well, that kind of leads me to my next question. If the bridge is gone, you're suggesting people can walk through the stream with their bikes?
No, Your Honor, that's not our suggestion. Our suggestion is there are multiple other access points to these public trails over private property that are accessible to members of the mountain biking club and, as far as I'm aware, to the general public in other locations. My understanding is the users of this particular access point could bike down Irish Settlement Road not too far to also access these same trails. And my understanding is that these trails were previously accessed before 2021 when the bridge was built. And so if they were accessing the trail before the bridge, they will be able to do so again.
But you're saying, oh, I'm sorry. Bridge or no bridge, they can't access it where they want to here.
Not in this location, Your Honor, correct.
Okay, and why if no bridge? Why can't they access it?
That is because this bridge is located within a river corridor area where.
But if the bridge is gone, why can't they access it by walking across the stream?
I think they could, but I do believe that would still be a significant change in use that would require a permit because it's gone from a private individual family using this property to an access point or a trail that is generally open to the public. And in each case that is looked at, the de minimis recreational use issue has really highlighted public nature of the use.
But how is it land development if there's no bridge?
That's because there is a new trail connected to the bridge. There did not used to be a trail on this property connected to the other mountain biking club's trails.
The trail's not going away. I mean, the trail could still be there and somebody could just say, well, they're just going to ride across or walk across the stream without the use of a bridge. And mountain bikers do go across streams without bridges all the time.
Yes, that can happen, but I believe if you look at the project as a whole, which needs to include the new trail that was built on the property in about 2021, I believe that constitutes land development. It's also subject to regulation under the zoning ordinance because it's within a stream river corridor. And within that 100-foot setback that is required of those corridors. And this access point was not the only potential location to access the trails. The landowners could have allowed the mountain biking club to use their driveway, which already crossed Settlement Brook and wouldn't require a new access point. But because the landowners prioritized their privacy interests, they decided they didn't want it near their house. I would point out that I respect their privacy interests, but that cannot be a paramount interest and trump the legislature's mandate that river protective corridors are important ecological systems and are needed to protect water and our natural resources along the rivers and to prevent flooding. So this is a situation where they have other alternatives that they just did not consider.
I'd like to ask you a question about that, but Justice Johnson had a question before I go.
Well, I'm just confused by one of your answers about the sort of scope of what's in front of us and your argument that we could settle this matter. I mean, it seems to me that the principal issue you appealed is that that this was de minimis and therefore there were no regulations that applied. So if we reversed, it's got to go back, doesn't it, for another hearing? And in fact, there could be the same result after consideration of the application of regulations, correct?
I believe that's correct, but I also think it is well within this court's discretion and jurisdiction to look at the record and consider whether or not there is even evidence in the record to meet those requirements. And our position is there's not enough evidence in the record, and the mountain biking.
But if the environmental court is committed an error of law, why doesn't it get the first crack at trying to figure out if it's made that error, then what the facts are that and what regulations apply? Just seems odd that he
Your Honor,
would do that.
I understand that concern, and I think that is typically the way you would handle this. But my point is just this is a situation where I think the record is clear and unambiguous that there's not evidence in the record that is needed to meet those requirements.
Well, let me, if I could jump in, let me ask you about this. This was a court trial?
Correct.
And there were findings of fact that the Judge Durkin made?
Correct, yes.
Are you challenging any of those findings?
No, Your Honor, just with the caveat that it's our position that the finding that the project is a de minimis recreational use is not a factual conclusion. That's an issue of law.
Well, he makes a finding, for instance, that the bridge did not require, and this is quotes, any notable disturbance of land such as excavation, filling, or clearing of vegetation. And then he goes on to distinguish it from those two cases, Schreiber and LaBerge, where there is a significant difference on the facts, it seems, between those cases and this situation. I mean, LaBerge was a racetrack of some kind, go-kart or something like that. I remember that case. And Schreiber, I looked at it this morning, is also, it's like a shooting range or something like that, isn't it?
That's correct, Your Honor.
Yeah, so, I mean, what about this finding that I read to you? Are you challenging that? And I don't see it in your brief if you're challenging that finding. I'd like to know where it is.
I don't believe that we need to challenge that because it's not, that has to do with whether or not there was land development. So
How do you distinguish, why are you distinguishing it that way?
So I think to answer your question, Your Honor, it might be helpful to point out the facts that distinguish this case from LaBerge and Schreiber, because I think those cases are very instructive. LaBerge, the fact is that the use of the motocross track was twice a week for a few hours. It was not an everyday use. It was not open to the public. And it is a racetrack only in the sense that the landowners themselves rode around in circles on a 1/8.
We had a picture of it when we heard the case. Remember
Yes,
the
we
case?
did.
Yeah,
But are you're hanging your hat on the public, non-public use here as opposed to no land development in LaBerge?
I believe there are three main factors in those cases. Was it a public or private use? And I think that is the paramount question. And I think each of those cases, and even the case cited by this court in those cases from New Orleans, all hold that, yes, we agree. If you are a landowner and you are a mountain biker, if you're a motocross rider, if you shoot, if you and your family want to make a recreational use of your private property, that can in some cases be de minimis. But when you open it up to the public and you don't know who is accessing your property and when, that considerably changes the factors. I think the other two facts that were really important are what materials were used in building this. LaBerge, there was no material brought on site. It was made by, the track was made by repeated riding and erosion.
Right, there was no structure in LaBerge.
Correct,
Right?
correct.
So no structure, no land development?
I do not believe that's the case, Your Honor. What I would say to that is first, it's our position.
I'm
now-
talking about LaBerge, not.
Oh, yes, there was no structure there, and so there was no land development. Correct.
Okay, but here you're saying, I assume you're going to get to the point that there is a structure.
Correct.
Materials were brought on site, wood, nails, etc.
Correct.
To make a bridge,
Exactly.
which is a structure which now means there's land development.
Correct. Your Honor. And I also would like to point out that the Underhill zoning ordinance doesn't just regulate structures. Under section 3.19 of the land use ordinance, structures and impervious surfaces need to be set back 100 feet from settlement road. So that shows there is an intent. We're not just regulating structures. We're regulating any development, any impervious surfaces, any structures placed within this river corridor. And that's because the legislature made the decision to say, these are important natural resources that we need to protect as a state policy. And it's needed to protect human health and the environment, which are also factors that each of the cases considering the de minimis recreational use point out. It wouldn't be a de minimis recreational use if there was a concern for the public health or safety. And here we have a legislative, essentially a mandate saying, if you put structures, if you put impervious material, it will impact human health.
I'm looking at Article 3 of the Underhill. You know, these acronyms are just enough to drive you crazy. Underhill Unified Land Use and Development Regulations. I'm not going to cite the acronym. Anyway, in the 3.19 references surface waters and wetlands, and it says that the following are allowed within local required riparian and wetland setbacks and buffers. And it defines riparian buffer as half of the required setback. Anyway, it from the photographs in the printed case, it did trying to understand this in the context of what actually was there on the ground. It didn't look to me like that there was anything beyond that was done beyond with the new bridge, okay, beyond what it is that this allows. Am I wrong? Am I wrong about that?
That's a good question, Your Honor, and I would just point out that in the record, you will see that there was actually litigation over
That question,
discovery about what's connected to this bridge. You don't just build a bridge unless it goes somewhere. And we requested information about what trail is connected to this bridge. The Mountain Biking Club's position was it is not relevant. It was not on the zoning application. And so we were not entitled to discovery, and they weren't allowed to introduce evidence about anything that wasn't produced in discovery, like what is beyond the trail. And it's been our position that that is very relevant, because if you take and segment a project into many discrete parts, it can fall under environmental protection. And so you need to look at the development as a whole. And I would say that it was an issue that the Mountain Biking Club didn't fully disclose what they were building on that property.
Do you dispute that the town of Underhill could give a variance here on the setback, both the Fuller Road setback as well as the wetlands?
Yes, Your Honor, I very much dispute that. I would point out that variances are the exception, not the rule, and there's a rigorous test that you need to meet to obtain a variance. And I think that the most important two factors are, was the harm created by the applicant? Here, that answer is unequivocally yes. They decided where to locate the bridge. They could have accessed the trails at another point. They could have built an access point that didn't cross a protected river corridor. And then the second issue is, can the landowner make any reasonable use of the property? Having a residence on the property and living there is a reasonable use. This isn't a variance case where there's an irregular shaped property that doesn't meet all the setback requirements, and so the landowner has no opportunity to develop the land. Here, the landowner is enjoying the land. They live there. The problem is there is just, and on top of that, the Mountain Biking Club admits and concedes they didn't consider any alternatives, and that is a part of that analysis. So
Wasn't that because there was already a structure there? I mean, there was a small little footbridge?
there was, Your Honor, just a small little narrow footbridge used primarily and only by the family. There was no trail connected to the footbridge. And I would say that there was a substantial change in use as well when you took out a footbridge that was used by a landowner privately and put in a bridge, a boardwalk, a ramp, and connected it to a mountain biking trail that is generally open to the public. I think those facts matter.
okay. I think your time has expired. Thank you very
Thank you.
much. We'll hear from counsel for the appellee. Please come on up and feel free to adjust the podium as you wish.
Good morning, thank you.
Please introduce yourself and your client.
Nicholas Lowe for the Brewster River Mountain Bike Club.
Thank you.
The only question before the court today is whether the bridge is a de minimis use that's exempt from zoning. If the court decides that it's not exempt, then the case has got to go back to the environmental division for the trial court to make a determination of if the bridge isn't exempt, is it entitled to the variance and a permit and approval? There was a full day merits trial on those issues, but the court did not make any findings on those specific issues. And so this court doesn't have any findings to rely on. If it wanted to make a full determination, it would involve scouring the record and making findings at this level, which the Supreme Court does not do.
Is there any question here that the town of Underhill was attempting to regulate what gets put in the waterway? That there's certainly consideration of where recreational trails can be, and the ordinance specifically says not within the waterway setback.
Again, the court didn't address that. There is language in the regulation that touches on this issue. But looking at that regulation first really gets the analysis backwards. And I would point the court to the case in Ray and Miller, which was decided right after Schreiber and is referenced in our brief. In that case, there was a convenience store in Montpelier, and the owner of the store bought the lot next door. And that lot had a mobile home foundation. They brought in gravel, leveled the gravel to the top of the foundation, made a parking lot for the convenience store. The gravel went into the zoning setback, and the question was, is this a structure? You don't start with the question, well, is it in the setback, and so does zoning apply? The court in that case starts with the question, is it a structure, and so is it something that can be even regulated through zoning?
Are you saying a bridge is not a structure?
That's the point, yes, Your Honor. First, you say, is it a structure? Can it be regulated?
Why isn't it a collection of materials that are brought together in order to construct something?
In the colloquial sense, of course, it is. Just like if you have a picnic table in your backyard or a kid's swing set. It's something you bring in material, maybe hammer some nails into some wood, you're building it. Is it a structure that's regulated by zoning? Probably not. And this court hasn't addressed that specific question, but in Schreiber, the court did say that the activity in that case, the landowner, quote, constructed a shooting berm for the shooting range, but it's not a structure for zoning purposes. So simply building something in the colloquial sense doesn't mean it's a structure for zoning purposes. I think, I think it's more akin to the what was done in Miller, where you have create an underfoot surface. Clearly, you're building something, you're creating something, you're changing the ground, but it's not something that zoning regulations are intended.
Mr. Lowe, what's the standard of review regarding the trial court's finding that it's de minimis recreational use?
Well, I think this may go to the ultimate conclusion, the legal conclusion, that it's an exempt de minimis use. But there's a number of findings that are similar to what you just said that are subject to clear error review. The court did make a number of findings. They're supported by a lot of evidence in the record. Based on those findings, we can go through the roadmap that we have in Schreiber and LaBerge, reach the conclusion that it's a de minimis use, not subject to zoning, and affirm the trial court's decision.
Is that true even if the bridge is a structure?
I think under the statute, the enabling statutes for zoning in Title 24, and in the ULUDR, the zoning regulations issued here, which has a definition of structure that mirrors the statute, you would conclude that it's not a structure, and therefore it's not regulated under zoning.
But LaBerge, one of the factors it points to in finding no structure there is the absence of any wood being brought in.
LaBerge's decision does point out that they used on-site materials. But then again, in the Miller decision, clearly there was gravel brought from off-site. So I don't think that's a final determinative factor. It may be one consideration. As the chief pointed out, the trial court in our case specifically noted that the disturbance here was much less than in LaBerge. There was no excavation, no filling, no clearing of vegetation. This is a simple wooden bridge that they brought in some wood and put it together with hand tools in half a day.
All right, so let me ask this question, and I'm sorry to keep interrupting you. When does the use not become de minimis anymore? Where do you draw the line?
It's a good question. I don't know exactly. I don't think it's this case. I think you can go through the framework that was provided in Schreiber and LaBerge, where you look at minimal impact, recreational use. There's this question of use by the public. I would point out, addressing that specifically, In Schreiber and LaBerge, the use was not exclusively by the landowners. In Schreiber, the shooting range was used by family, friends, and a local shooting club. The shooting club used the range for 4 annual picnics and to conduct several safety courses. And use of the range increased through the landowners' involvement with the shooting club. In LaBerge, the track was used by the family, the landowner's family, their friends, and their guests. And I would point out there's an Oxford comma in there, so it's friends, comma, and guests. So I think we can consider guests to be a separate category from friends. It indicates kind of a broader use.
If they'd advertised, say, come ride the beautiful new bike trail, does that change things?
It might, Your Honor. And the evidence was, in this case, there was no evidence that it had been advertised at all. And the trial court pointed out that information about the trail, this trail is not readily available. There's no map of the trail. And in the record, the evidence at trial was actually that the mountain bike club intentionally did not make a map at the request of the landowners to kind of keep information a little bit quieter about the trail.
But the local community would know the trail was there. The local mountain biking community would know the trail was there.
That's not clear from the record. What we do know, from the record is that you can use the trail if you park 3.5 miles away. There's no parking at the location of the bridge. And so you have to get there through trail network or on the public roads. There was information in the record that it's fairly lightly used. The court made a specific finding that it's used by the public, the landowners, and neighbors, but without really clearly qualifying, the balance of that use between those three groups. The record is not entirely clear on the balance between those three groups either.
So how does the appellant makes the argument in their brief that there's no written agreement with the landowner and that it can be revoked? How does that play into this analysis at all?
I think the appellants made that point. What they're trying to point out, I believe, is that if this court determines that this use is subject to zoning, and then it goes back to the environmental division to determine, is it entitled to a zoning permit? The appellants are arguing that the mountain bike club is not the correct applicant, but the applicant should be the landowner. And the record's very clear that the landowners were fully involved in the process, from writing the application to going through, the application process and the hearings. If I can briefly just touch on another issue, the appellants have pointed out that there should be a different analysis here because the bridge is near a stream, so it's unlike LaBerge and Schreiber. This really gets the analysis backwards. The threshold question is whether it's a de minimis use exempt from zoning. Only if it's not exempt do you then open the regulations and look at what specific provisions apply. Again, in Miller, this court did not look at whether there's a setback and then based on that determine if it's subject to zoning regulation. You look at whether it's subject to zoning regulation first, and then you look at the setback.
Okay, but in Schreiber, we said Cabot's empowered to regulate recreational shooting activities through its zoning authority, and indeed has chosen to regulate trap and skeet shooting while remaining silent about target shooting. Here, the town of Underhill has not remained silent about placement of bridges within the stream.
That's correct, but above that in Schreiber, the court's principal analysis is looking at the statute and looking at, is this a type of zoning activity that can be regulated under the enabling statutes for zoning? The Schreiber decision the appeal was framed as a question of state law. Is it a use that needs a permit under state law? And the court analyzed it under those enabling statutes and determined that it can't be regulated under the enabling statutes for zoning. And so you have the umbrella enabling statutes analysis. And then as you point out, and I think it's dicta, the court says Cabot could regulate recreational shooting. But that's got to be looked at under the umbrella of, but would that be within what's authorized in the enabling statutes? And maybe the regulation there would be if you construct a big stand, bleachers for an audience to observe recreational shooting. Maybe that's enough of a structure that it can be regulated under the state enabling statutes team. But I think even in Shepherd, if the Cabot regulations said you can't build a shooting berm, and the berm is something that's de minimis and can't be regulated under state statute, then the Cabot regulation may be ultra vires and can't be enforced because it goes beyond what can actually be what's authorized in the enabling statute.
So your point, I guess, is there are structures and then there are structures.
Exactly. It's very simple.
And Mr. Lowe, this bridge replaced an old bridge at the same location.
That's correct. There was a bridge previously at the exact same location, a little bit smaller. And, you know, it is, as the court pointed out, it is in and near this stream. And I just want to go back to this and point out that the purpose of zoning is not environmental protection. We have a very rigorous state environmental protection program administered by the state. For example, you can get a zoning permit to build a house, but if your driveway cuts through wetlands, you'll need a wetlands permit from the state. If it goes over a stream, you might need a stream alteration permit. If you're disturbing a large surface, you might need a stormwater permit. None of that stuff is in zoning. And the reason for that is because the state agencies have the expertise. They have engineers, the river corridor experts, the wetlands biologists who know those areas and they know what needs to be regulated. It's not something that anyone in the zoning scheme has any expertise. And I think there's a danger of letting zoning go too far in regulating those environmental issues because the zoning administrators, the zoning boards, they don't really have the expertise to get into that and understand, you know, what needs to be protected and how.
So any issue involving the stream or disruption of the stream would be through the Agency of Natural Resources or one of the other state agencies?
That's right. And in the record, there is evidence in the record that there was a determination by the state that a stream alteration was not required for this project. And so, you know, it had been brought to attention of the state. But I think, again, you know, it's not the point of zoning to take a deep dive into looking what's the impact to the stream here.
But are you suggesting that establishing a setback is going beyond where the town is allowed to go in zoning?
No, I think a setback is allowed. Whether the setback applies, again, would have to go back to the environmental court, and it's not a question that's reached unless you determine it's not a de minimis use. Thank you.
Thank you very much. Please call does the appellant have any time?
Appellant has no time remaining.
Please call a conclusion of the hearing.
Next hearing for the court is scheduled